What happens when thousands of legal workers suddenly lose the right to work overnight? Well, the automatic buffer is gone. Tonight, we unpack what that means for families, companies, and careers. Thank you so much for joining us here on Immigration Talk Show and also on Wasden Law Channel. Thank you for being here with us. Please feel free to join us wherever you're watching us. We are live right now on YouTube, LinkedIn, Facebook. You can also check us out on Twitter, and that is X, and on Instagram as well. Today's topic of discussion is going to be how will the end of automatic EAD extensions disrupt the workforce? We're going to discuss on that, but we have an important disclaimer for you to keep in mind throughout this whole session. So, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And today, to help us get deeper into the topic of discussion and have our questions answered, please help me welcome our guest for today, none other than Attorney Justin Rivera from Wasden Immigration Litigation. Hi, Justin. It's always good to have you.
Hey, thanks for having me. Pleasure to be here.
Thank you. Thank you. And well, the topic of discussion, the end of automatic EAD extensions. This was a sudden change and cause got so many people confused. What do you have to say? What can people expect from today's discussion?
So I would say this was an inevitability from the Trump administration playbook. This was something that was litigated over during the first administration, and you could kind of see the signs that it was going to come eventually when in January, when the Trump administration came in, they chose to not renew the agreement that had been struck from prior litigation in which the government agreed to continue adjudicating H4 and H4 EAD applications when they were filed concurrently with an H1B renewal. So once the government reneged on that, essentially, it was only a matter of time until they were going to try and find some way to go after the EAD. There was actually litigation that had been, moving prior to the issuance of this interim final rule that sought to eliminate the EAD. It was unsuccessful. Shortly after that time, you saw this IFR come out. What is an IFR? Just so we're on the same page, it's called an interim final rule. So what they're basically doing is they are putting forth this as an emergency. They're saying, we have to make these changes, and we can't go through a notice and comment period like traditional Administrative Procedure Act rulemaking requires, but rather we're going to go through a quick period and immediately implement the rules. You could send us comments, but we don't have to consider them because there is such a need for this to be enacted. And we'll get into the farce that is the idea that there's a need for this and what the justification is. But at the end of the day, my opinion, and it's likely shared by most of my colleagues, is that the purpose of this is to make immigration harder. Like most of the policies that have been implemented by the current administration, almost said regime, the current administration, it's being done under the guise of security for the purpose of delay, right? The end game here is delay, make things harder, make the process worse. The whole impetus of the implementation of the extensions of work authorization by previous administrations, up to and including most recently Biden, was we understand as USCIS that we lack the capacity to timely adjudicate these things. As a result, because these are renewals, meaning people have already held this benefit before, we're going to give them an opportunity to have an extension for a period of time while we adjudicate, right? So that was always the purpose of it. This IFR goes in another direction and instead says, hold on a second, we can't just give people a benefit without vetting them. What if we don't vet them? What could they possibly do? And if you're wondering what is it that they could possibly do, they have one instance that is cited repeatedly throughout the interim final rule, and it was a circumstance in which a man in Colorado assaulted a group of individuals who were peacefully assembled, trying to draw attention to the fact that there were still prisoners that had not been exchanged in Gaza, between Gaza and Israel. This one individual attacked them, apparently had an EAD. How the EAD plays into whether or not this person should have legally been in the United States, Not really sure. But this one guy doing that means that everyone else should not get an automatic renewal because they need to be vetted. So we'll get into the details about that. We'll get into, to be blunt, the nonsense of it. And hopefully I can give you guys a little bit of positive hope with an understanding that Wasden Immigration Litigation will be litigating this matter in court probably sometime in early December.
Thank you so much, Justin, for giving us like a peek into what we can expect in today's discussion. And friends, I think it's always best to, get help from an immigration attorney to help with your visa status or, what you're going through, especially with your immigration case. So always consult with them. They will give you the best direction on how to go about it, and always keep your documents updated and yourself updated, on what's going on. So don't forget to subscribe to our channel for that, because we bring you the latest updates on US immigration, and our handle is at Immigration Talk Show. And also, it's really good to see viewers already commenting. Please stay with us. We're going to take them up. Hi to Imran and Sid Mohan. Good to see you. So, my question to you would be, who is held accountable, Justin, when an EAD renewal delay causes a legal worker to lose their job, whether it's the individual or the system itself?
So it's the individual, obviously. Like almost any aspect of U.S.-based immigration, the immigrant is almost always the one left holding the bill because that's how the system works. Um, in this circumstance, if you read the IFR, which I advise you guys, if you have an opportunity to, please go read through it. It is long. It is a slog. There are some legalese nonsense in it, but really read into it and look at what they're saying their justifications are and what the end results are, because part of this is they have to explain what the economic impact of this is going to be. And nestled in IFR is, in my opinion, the root cause of the implementation of this policy. So it talks about what will happen to businesses who can no longer employ these individuals because they're no longer subject to the automatic extension. The IFR says that, well, those jobs can be filled by other workers. And other workers, let's not hide the ball here, US born Americans. So they can hold, take these positions, or the organization can transfer the responsibility among the currently employed individuals as a way of bearing the cost until the EAD subject individual is able to work again. And that's it. I mean, that's what they're trying to do here. They're basically saying, if you have an EAD, file 6 months before it expires and hope we adjudicate it on time. Do we promise we're going to adjudicate it on time? No. No, we're not going to be held to any level of standard whatsoever. We're just going to say, hey, file it when you can. We'll see if we can get to it. If we can't get to it and you lose your job, we don't care, because that's kind of the purpose of why we're doing this. And so, yeah, it's the individual that deals with it. Now, the consequences of it will be far-reaching, because as we know, the EAD for the H-4, the EAD is not employer specific, right? So an individual can work for themselves. They can work anywhere for any other business or industry. Ergo, that EAD is far-reaching. You have people in tons of different fields that utilize this privilege to work in the United States while they're here legally. When that impact is becoming felt is when we're going to see individuals in important fields for society lose their work authorization. We're talking about medical professionals, individuals in healthcare, individuals holding high-level positions within organizations such as, managers, directors, all those kinds of things. So those kinds of people who are going to be directly impacted, it's going to hurt them, and it's going to hurt their household. But it's also going to hurt their employer, because now the employer is looking at a circumstance where, a month ago, there was already a baked-in policy that allowed for them to not have to worry about the EAD process, because these people were able to get extensions automatically when they filed and followed the conditions required. Removing that creates an issue for them, because how important is the worker? What does this person do? Is it specialized? Is it something that can only be done by a few people, maybe in the world? So those are the kind of individuals that our firm is looking for in terms of plaintiffs, because we do want to show that this isn't just going to impact somebody who's opened an Etsy shop. And you know what? The person that opened an Etsy shop that is being impacted, you are important too. But the most sympathetic plaintiffs are going to be the ones whose job loss not only impacts them, but impacts their community. Because, maybe it's a rural healthcare provider or a dentist or some other field. Heck, maybe it's a therapist in somewhere where a town where that's the only one, and to lose that means these people are going to lose access to important mental or physical health care. So those are the individuals we're hopefully looking for. But to kind of put a button on this, it is the individual. I mean, the individual is always the one that ends up, stuck with the bill when these policy changes happen. Employers can always pivot if they have to find new employees. If it's an incredibly difficult situation, it becomes more nuanced, opens the door for more of an understanding of litigation. But inevitably, the people are the ones that are going to suffer from this.
So true. And I think only the lucky ones really get what they really want, as in their visa or all of their things, sorted. Because I can't say that people are not trying their best. They're doing their best. They're hiring immigration attorneys. They're doing everything possible with, getting their documents in the right place and time. But only the lucky ones are getting through it, I guess. So let's see what happens. And it's been a really um, tough year, I can say, when you look at immigration. So many changes, so many things coming in, and challenges every now and then.
Yeah, it's been. I think I can easily say I've been practicing not super long, but I'm going into 8 years now. All of my years have been spent in immigration, business immigration specifically. This is, in my opinion, the most volatile year that we've ever had, hands down. And, I think we all knew coming into it that we were going to see a very different tone with immigration as opposed to what we had dealt with over the last 4 years. I don't know if everyone was fully ready for the level of cruelty, to be blunt, in the implementation. I'm just being honest. I mean, issuing notices to appear for people who have lost their jobs while in a valid grace period to move to another employer, issuing notice to appears for people on H-4s who get denials on their extension of status over technicalities. These people are not criminals. These are people who have lived and worked legally in the United States, usually for years. And a lot of them are kind of in a bad spot just because of how immigration works in this country. And they're subject to a backlog. And it's making them have to stay in a non-immigrant status much longer than some of their other, the other people that have immigrated to the country. And I think that it's ridiculous to target those people in any capacity. But the thing of the matter is I mean, that's the name of the game. That's the point here. I think we have enough data over a year to look back and realize that looking at each other and saying, wow, this is ridiculous, is not sufficient anymore. We need to be pushing back as much as possible, and that means litigation where it's necessary.
True. Absolutely. And folks out there, thank you so much for joining us and watching. Let us also know what are you going through right now. Maybe what is your status? Where are you watching us from? And drop your comments if you have questions for Attorney Justin Rivera. Comment wherever you're watching. And also don't forget to share this with your friends and folks who could benefit from the information we are discussing in today's webinar. So also, hi to Robert and Subrat. Thank you so much for joining us. We are going to take your questions. But for now, I got a couple more, Justin, and I just wanted to, talk. We were speaking about vetting. So this vetting improvement, when it's leaving thousands of legal workers unemployed. So what does the government, why does the government call this, vetting improvement?
So the vetting is a fallacy, right? Like, to be blunt, it's a fallacy. And an individual, when they apply to extend their status in the United States, is already going to go through a period of vetting, right? Because the government is going to look at all of the information and make, in their discretion, because that's their favorite word now, is discretion, going to make in their discretion a determination as to whether or not adverse factors exist that could stop this person's eligibility for the extension. Now, an individual who comes into the United States is vetted at multiple steps, right? They're vetted when they apply for the visa at the consulate. They're vetted when they enter and are inspected by CBP. And they are vetted periodically, unbeknownst to them, through these systems that USCIS has access to. I'll give you a perfect example of that. If USCIS lacks the capacity to perform vetting processes whenever they want, Why at the beginning of this year or I guess it was closer to summer, why did they kick a bunch of kids out of SEVIS? They kicked a bunch of kids out of SEVIS that weren't applying for extensions. The kids weren't, they didn't need approval for OPT or STEM OPT, but they kicked them off because they have access to systems that show if individuals have been arrested in the United States, specifically fingerprinted. So there are already vetting procedures that exist that are utilized continuously by the State Department, USCIS, and ICE as a way to vet individuals. Let's also take a step back and really look at the long-term ramifications of the implementation of this policy and the vetting. If an individual applies for an EAD renewal and the end date of their employment passes, the individual is still admissible to the United States if they've timely filed an extension, right? So by not having an EAD, this person who USCIS claims could be, I don't know, a nefarious actor, a terrorist, whatever it is they're drumming up, this person isn't forced to leave the country. So they're still here. And they'll remain here until there's an adjudication on their underlying non-immigrant status, whether or not the vetting occurs, before the EAD is issued or not. So it doesn't stop anything. And now we get into the real nitty-gritty of the nonsensical nature of the implementation of this policy. So if a person's allowed to legally remain in the United States and they are a bad actor, they want to do bad things, is the impediment to that activity their work authorization? Is the fact that they can't work going to mean that they have now been thwarted from their activities, right? They'll never be able to do anything. The case that they use, the man in Colorado who assaulted individuals who were peacefully protesting, I very much doubt that the only thing holding that man back in committing that act was whether or not he had employment authorization, right? That's just the case. And so it's silly. If you were to say, we're vetting people because we don't know whether or not their extensions will be granted or approved. Okay, that makes sense, but you're already doing the vetting in the first place. There is already vetting that exists. We know that. So what is this new vetting and how does anything change? The person stays here, they're still being reviewed. It just doesn't hold water. This notion that the work authorization is the missing piece and this is going to be what, stops a terrorist, because that's what they're really trying to lean on, if we're all being honest. They go far as to say it. They say part of the vetting is ensuring that remuneration is not occurring to individuals that, have ties to terrorism. Okay. Okay. Sure. But again, that's all really nonsense, because those vetting activities could occur and coincide with an automatic renewal. There'd be no need for it not to. And if you look at the equities here, isn't there more of a benefit to the government if these individuals are able to work and pay taxes than there is to have them stop working under the guise that they have to be reviewed more? And again, you get into the vetting itself. It's, what is it? They're saying, well, we got to run them through a system. We know that that's all automated at this point, right? We know that. We know that there's not one man who pulls someone's file out of a folder and sits down and opens it, reads every page of this person's activity in the United States, and then says, golly gee, I don't know, this guy's a bad person. That doesn't exist. It's an automated process. We know technology allows for the very quick determination of these things. In the previous litigation, I believe, and I'm not going to know the definitive number here. I apologize. It's been a couple years. But I do remember USCIS having to admit something along the lines of it takes like 12 minutes to adjudicate an H-4 EAD. 12 minutes, I think. So what is now added to this to create more of a hurdle, right? There's nothing really added. Their whole point, the whole reason for this is we're claiming national security is an emergency, so we don't have to go through normal rulemaking to create this. Vetting has to be done to stop these people from killing us with terrorism or whatever it is they claim. And as a result, we got to stop automatic work authorization, because if we don't, terrorism. That's it. And that's what they're going to have to rest on in federal court. So I would say that my personally held belief is that this is ridiculous, awful, and poorly drafted. It is reflective of the individuals who currently work in the administration. Okay? There has been a mass exodus in most of the levers of government that involve attorneys. State Department, Department of Justice, people are getting out, okay? Because people don't want to be a part of this. So what does that leave you with? It leaves you with the dregs. It leaves you with who's there. And so those are the people having to write these kinds of things. Just like with the $100,000 visa fee. You know, when that came out and we were all looking around going, who does this apply to? We can't even read it. It doesn't make sense. A lot of that reads this way too. If you really want to have fun, like you're sitting around, it's a Saturday night, you got nothing to do. Maybe you've just opened the first of a 6-pack. Go through this IFR, and I want you to see how many times the IFR cites to Fox News and the Heritage Foundation, which is a conservative think tank. Just do it for your own fun. Go through and look at all the times where they link to say, we're asserting this fact, Fox News. We're asserting this fact, Heritage Foundation. When your argument is built on the backbone of parroting the information that you already want to be true, it makes it a pretty tough argument to hold legitimacy to. So, yeah, I don't think the vetting leaving a bunch of people of unemployed. No, it's ridiculous. The idea that stopping people from legally having work authorization because one person could be a bad actor it's ludicrous. It is unbelievably ludicrous. I cannot say it more bluntly. I mean, yeah, it's ludicrous. And gosh willing, it's something that is very quickly struck down in court.
Well, what can I say? I think most people are feeling paralyzed because they're doing everything they can, and suddenly, these bombs are dropped, and again, they don't know what to do next. So,
Yeah,
friends, just stay with
I
us,
think the
and
final rule, just so you're aware, was tactically deployed on October 30th during the government shutdown for a reason. I think
oh,
that, but for the shutdown, they probably would have taken a longer view on this, but they saw an opportunity to seize and went after it. And that's speculation, but I'm just letting you know why I think that's why it happened when it happened.
sure, Justin, sure, for sure. Well, I think we should take a couple of questions from the audience. So let's start with this one from Subrat. Thank you for all your support. Please let us know when the litigation is planning to file against the decision and in how many days we can expect the court decision.
So we want to file in early December, but in order for us to file, we need plaintiffs. Okay. And the more plaintiffs we have that we can rope in to show that this is a concerning issue and a trend that's going to repeat, the more we have, the better. So I believe we've already begun to assemble plaintiffs. I'm not 100% sure of the numbers because honestly, we get emails every day and it's hard to keep track of. So I leave that to my team rather than myself. But the more we have, I think the better case we can show. And so we do want to file in early December when this rule, the IFR, is supposed to be finalized. It's supposed to be the end of November. So when we file, what are we looking for in terms of expecting a decision? I think realistically, we get some sort of final decision in mid-January to the end of January. Would be my hope. Now, the big monster in the room is the shutdown, right? The shutdown is possibly going to create lags in the process, but the shutdown looks like it's ending soon. Great job for caving, Democrats. Thank you for wasting multiple months with a shutdown. Just my opinion. But yeah, I think with the shutdown ending, we should see a full steam return to normal processing of litigation against the government. So I would hope end of January is like the latest for a decision.
Thank you so much, for giving us some hope. And thank you, Subrat, for that very nice question. Let's take up Rajendra's one. Rajendra is asking, what legal safeguards and proactive steps can Indian professionals take to avoid job loss or status issues if their EAD renewal is delayed?
I mean, they're saying file 6 months out and hope for the best. That's really what they're saying. I'll tell you right now, if they're playing out of the same playbook that they did from 2016 to 2020, they're going to basically kibosh expedite requests. And for those of you that don't understand kibosh, they're going to clamp down. They're not going to give you an expedite request because they don't want to. They don't want you to work because if you lose your job, that's a win for them. And so applying really far out, maybe trying to expedite once or twice would be great. I would be pretty upfront with your employer and let them know, like, hey, I'm taking every step that I possibly can to get this expedited. Is there anything you can do to help me? If your employer is willing to produce a hardship letter, something showing that, this is how much money I make the company, and if I leave, they can't just fill that hole. That's something that you could hope the government would consider. I don't know if they're going to or not, but build a case, right? Let's take this, John and I, we did a webinar on this last week, and we were kind of asked this question about what's the worst case scenario in the litigation, right? If we don't get some sort of sweeping success and invalidation of the rule, then it becomes death by 1,000 paper cuts through mandamus. So what that means is we're going to file delay litigation after delay litigation after delay litigation, showing people who have waited, the entire amount of time and still don't have their EAD authorization. Is mandamus going to be impactful and successful? Yes, I think so. It has the capacity to. But we don't want to even get to that point, right? We don't want to have you guys coming to pay us thousands of dollars to tell the government to do the job that they're supposed to do already. And so that's why we're attempting to go through litigation this way and get a clean win that we can use for everyone rather than having to go piece by piece by piece. We had to do piece by piece back in 2016, 2017, whenever it was they made the rule change, maybe even 2018. I'm getting old, guys. Cut me a little slack. But we can and will explore that if we need to. But John, who is way smarter than me, John this time wants to attack this right out front, and we want to hit this hard, and we want to get rid of this so that everyone gets to, gain from our win. So yeah, I mean, if everything doesn't go the way we want it to, and it turns into mandamus city where we're just mandamusing the government every other month with more and more plaintiffs, then that's what we'll do. To get you guys your EADs. But I'm telling you truthfully, we had to do that in the past. We really don't want to do it again.
Absolutely. And yes, big shout out to Jonathan Wasden. Go check him out on Wasden Immigration Litigation, friends. And also, don't forget to check out Attorney Justin Rivera today, who's here with us gratefully, and visit this link, which you can see on screen. So also, you can reach out to them if you need a one-on-one consultation or want to, get more of your questions answered. So thank you so much so far.
Yeah, and anybody who wants to be a prospective plaintiff, anyone who thinks, hey, I want to be involved in the litigation, I want to let you guys know two things up front. One, you can email us at support@Wasden Litigation, something like that. You can email us and just say something like, hey, I want to be involved in the lawsuit. Here's some of my information. We'll reach out to you and we'll talk about whether or not we think you'd be a good fit as a plaintiff. Secondly, we do have the ability to mask your identity. I know that there are people who fear retribution from the administration. I would have told you, in January, that's silly. You should, okay, yeah, it's real now. The dude's out there literally suing everybody that said a mean thing about him while he wasn't in office. So I understand any level of hesitancy. We can bar your name from the complaint. You would be John Doe or Jane Doe, and your information would only be known to the court and to our office. That's it. So if that's the kind of thing that's stopping you from moving forward or wanting to move forward, we can take steps for you. So that all being said, though, plaintiffs that sue the government are usually the ones that the government doesn't mess with as much moving forward because they just don't want to deal with it. So we'll see what kind of comes in. But thank you for letting me get on my soapbox there for a minute.
No, thank you, actually, really. And talking about expediting, so we have Sujit who has a question. Could you please advise on all feasible steps we can take beyond simply applying 6 months in advance and hoping for approval to expedite the process and reduce risk of delay?
Yeah, kind of like I just said on the last question, you just file early, try to expedite if you can. I don't know if they're going to give a dang of expedites at this point. I think some of the best expedite arguments come from one of two things. Either A, your employer is willing to step in and say, hey, we need this person. If this person can't work for us, we're going to lose money. We're going to lose contracts. We're going to lose business. So we need them. B do you have kids or a partner, and is your family's health insurance tied to your job? Because if your family's health insurance is tied to your job and you lose your job, then your family loses health insurance. Those are sympathetic arguments that may be able to move the needle in some capacity. But outside of that, there's really not much else, that you can do to really expedite. And it sucks, but I can tell you guys, when we were doing mandamus lawsuits in the last administration for EADs, we had all of these people who had requested expedites and literally worked with lawyers to craft arguments to say, to basically tell you the kinds of things I'm telling you guys. Under 5%, we're getting granted the expedite. So, I mean,
Yeah.
Unfortunately, you guys have to realize, if you haven't realized already, that we are no longer dealing with a rational actor in USCIS, because they are an adversary at this point, right? They're not providing a service, they're providing enforcement. They are a new arm of the government that has been weaponized to attempt to find ways to deny people's cases. We go to court on things this year that I can't believe we're having to litigate. Cases that are clearly not denials, that have somehow been denied, almost as if they're begging to be sued, or they really just think we're going to give up. It's insane. So I just really feel like you guys can do everything you can in terms of trying to do, expedites and everything. But to tell you guys that that's going to be what fixes your solution is just untrue. So yes, it's an option, but I'm not sure it's a great option. It's basically like if you have an illness and I'm giving you medicine, but I know the medicine's not going to work, but I'm still just handing it to you because it's a solution. So I don't think anything really changes this outside of litigation.
There you go. Thank you so much, Justin, for taking that up. And, speaking about families, what are families supposed to do when their only source of income is an H4EAD and is about to expire with no renewal in sight?
Well, it shouldn't be their only source of income, because they're going to have an H-1B holder spouse, right? So they should still have that H-1B holder that has a job and can work. However, cutting a dual household income down into a single income would be difficult for anyone. Much less when we're in an economy right now that I don't care if people aren't willing to come out and say it. It's not great in terms of job markets. I'm sure you guys are aware of this. Job markets, long-term retention. When you see these larger companies continually doing layoffs on what is almost becoming an annual basis at this point. So no, it's not great, because it puts you in a circumstance where you have to make drastic cutbacks to ensure that you can maintain the lifestyle that you hold. Gosh forbid if you're you're an EAD holder and you're a direct contributor to the rent or the mortgage or a car payment, your kid's daycare, and those expenses are now things that just go out the window or are completely put on the other party by no virtue of your own mistake, merely because the government seeks to utilize you as a tool, a pawn in a long-term process to make America great again, or whatever it is they're claiming. It's not fair. I would just say, this is going to sound horrible, but I just got to be honest about it. If you're on an H-4 EAD right now in today's world and you're filing 6 months out, if the world doesn't change and if processing stays the way it is, and I would just say you got to start saving. Just generally, probably cut back now on spending, just in case this becomes a long-term issue. I really hope it's not, but I think those are the kinds of decision-making people are going to have to be doing. And what is so incredible about this, it truly blows my mind. They talk about the economic impact in the IFR. I didn't see anything about the loss of spending power for households. I truly didn't. It's almost like an afterthought. It's this notion of yeah, it's going to suck for those people, but national security trumps everyone. So obviously national security, and then they say it 550 more times as if that'll make it true. But I really can't believe people won't take into analysis here, drilling down on the reality of If H-4 EAD holders begin losing their jobs or their spending power, what does that do to the market? I believe right now, and this isn't, I believe it's 19.2% of the current US workforce is foreign born, right? Now, obviously, that's not all made up of EAD holders, but they are a percentage of the pot. So if you take that percentage of the pot and you begin taking away these people's work authorization, not only do they no longer pay taxes into our system, which is great, we can then use that to send to a foreign country, right? But they also can't buy things. And I don't know if you guys know it, but the economy needs you to buy things to work. So when people begin spending less, where are they going to spend less at? Service-based industries typically. They stop going to restaurants. They stop going out to eat. They're not buying that new pair of tennis shoes because the old ones are just going to have to do, you know? And when they pull back their spending power, it hurts everyone. So this idea that a household is going to just be able to make it with one person's income because we need to take 9 months to adjudicate your EAD is just, it's ludicrous. And I believe that that's one of the strongest arguments to make in court to a judge when you're looking at this and saying, why do we need to do this? One person who had an EAD threw some rocks at some people or, did whatever they did. And I'm not trying to marginalize it. That's horrible. They shouldn't do that. They didn't do it because they had an EAD. But anyway, this one person over here means that we need to tell all these other people to stop working. It shouldn't hold water, and hopefully a judge sees that.
I think all we can hold on to is some hope. So let's get at it. And we have DKJ also, Justin, who has joined us. I would really like to take his question. How long on average is it taking to get AOS, EAD, and AP recruitment? Receipt notice and approvals.
I have one right here that's a receipt that I can tell you we got it in the mail last week. And it was received by USCIS on October 27th. So we got it October. That was the I-131. This all comes together, guys. You file it together. They send you the receipts. It's really stupid, too, because they send you the receipts in different envelopes. So you get all of these receipt notices, and they're all the same, like for the same person. We can't bundle these. But anyway, so we filed they received on the 27th, and I picked this up on the 6th. So I would say a week to get it receipted. Approvals, you can look that up on USCIS's website, okay? You're able to look up the duration. Now, to give you kind of like an off the top of my head, I had cases that I filed at the beginning of this year, AOS cases, that have their EAD and an APs approved. I believe those EAD and APs, those approvals came in early October. So that was January to October. So that was my wait for those two. I think it was 2 cases or 3 cases. So I would say 10 months.
10 months, yeah.
The 485 you're going to interview for because they're making everybody interview now. So you're going to have to do your interview and then they'll end up adjudicating. I've seen some 485s pending for more than a year, going into 2 years now. But real big thing that I want to point out to everybody, just so you're all aware of it, because I think it's important to know this because I-485s are being adjudicated at a significantly higher rate now in terms of scrutiny. You get an EAD, right? And it's your choice whether or not you want to use that EAD. You can continue to maintain your non-immigrant status if given the option rather than using the EAD. If you use the EAD, the term we use is marry yourself. You marry yourself to the 485 adjudication. Okay? So what does that mean? That means if the 485 adjudication goes badly and your case gets denied, the EAD is revoked along with the advanced parole. And then you're dealing with a status issue. So generally, I have advised people, if you have the ability to do so, remain on your non-immigrant status, remain on the H-1B, the L-1, whatever it is, until your 485 is approved. That gives you an opportunity. And I'm being honest with you guys. I literally did an I-290B a week and a half ago where they denied this person's I-485 because they forgot to send their most recent 1040, their tax information. They sent everything else, okay? USCIS 2 years ago is not denying that case. USCIS is sending a notice of intent to deny and saying, hey, you didn't send in your tax information. You need to send it, right? Not anymore. Now they're going to say, ooh, a technicality, and they're going to deny the case if the document isn't there, right? Even if they issue an RFE and someone forgets it, whatever. It's a little faux pas. But look at the long range implication for that. If that person's married themselves to their EAD, they're no longer working subject to their non-immigrant status, and that's denied, you're in limbo. You're sitting there with nothing in your hand. You got no status. So I really tell anyone, like, yes, the EAD is awesome because so many of you are so understandably pissed off that you've had to work on an H-1B for like 12 years or 15 years or whatever it is, and you've been stuck with employers who tell you what to do because you don't have the freedom to move unless another company is willing to pick up your H-1B, right? So you get that EAD in your hand and you're like, F these guys, F everybody, I'm starting a business, or I'm going to go work at this company I've always wanted to work at who wouldn't do an H-1B. Totally get that. There can be ramifications for that action, okay? And it can even be small things that aren't even really your fault. So just take that into consideration when you guys choose whether or not you want to use the EAD.
Thank you so much. Thank you. And DKJ, thank you for your question. Please don't forget to subscribe to our channel and to everybody watching as well. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram. And also don't forget to check out Wasden Immigration Litigation. Also check them out on LinkedIn. So yes, we do have a lot of questions, and I just want to know how much time do we have with you, Justin?
I have a hard out at 11 because my dog is continuously sighing behind me. So if I do not walk them soon, they will probably explode.
Sure. Okay. So, when DHS calls work authorization a privilege, does that mean legal immigrants are now treated as temporary and replaceable?
So their usage of the word as a privilege is, it's an ancillary benefit. It's not the primary benefit, right? The benefit is that you get to be in the United States of America. And it's such an awesome country, and that you should just be really happy that you're here. To say it's a privilege, like, okay, this person's work authorization is something that the government can giveth and they can take it away. Yeah, okay, that's fine. What is the basis of the H-4 EAD, right? Why is the H-4 EAD even around these days, right? The H-4 EAD is basically around because the United States realized that while people sat in backlogs and their partners couldn't work, they would leave. And I'll give you a perfect example of this. I had 2 years ago, when I was working at a different law firm, I had an individual, a man, a Canadian man, who wanted to come to the United States on an H-1B, okay? So we file for him in the lottery. He gets selected. We get his H-1B approved, and he's all excited to move, and he wants to come to the U.S. So he says, okay, so my wife's going to be admitted in H-4. And I'm like, yeah, she's going to come in H-4. And he goes, okay, so when can she start working? I go, well, you got to get an I-140 first, right? We got to get you an I-140. And once you get an I-140 approved for your wife, then she can work. This man said to me straight up over the phone, yeah, I'm not coming then because my wife makes more money than me. So why the hell would I move to the United States? And my spouse, who is the primary breadwinner, will now not be able to work? And so he said, yeah, I'm good. I'm not coming. And I know, and before any of you start and say, well, why didn't you bring him in on a TN? The categories for TNs are really specific. He didn't fit into any one of them. So all of that is to say, why does the H-4 EAD exist? The H-4 EAD exists because we realized we would continue to lose out on talented people whose spouses could be granted work authorization abroad. Ergo, we have the H-4 EAD. To call the H-4 EAD a privilege is a little silly because it's really more like fishing bait. It's something we're dangling as the U.S. to say, don't leave yet, don't leave, we'll give you your green card eventually. But while you wait, we'll make sure that your partner can work. That way you guys can, have a more stable income. Maybe they are the primary breadwinner in your family. So it's very silly to me to sit there and be like, well, the H-4 EAD it's a privilege, something we're just going to give to you. And if we want to take it away, we can. Okay, but like looking at this on the other side of it, it's something that you had to create to ensure that individuals that have to wait for green cards don't bail on the US. So, yeah, I think it's silly. The notion that people are treated as temporarily and replaceable, I want to touch on that because let's look at this. Okay, if you're on an EAD, you can work anywhere. You can do whatever you want. You can open your own business. If you can't run your business, that's a problem. But let's even go to the micro of it and say you got an EAD and you're a greeter at Walmart. Okay, you're a greeter at Walmart. Could another greeter at Walmart exist if you lose your ability to work? Yeah, probably. But does the company want you to lose your job? No. They like you. They want you to be there. You're trained. You already hold a role for them. You're being paid and they know you're not a crazy person. That's going to go a long way. And you don't want to lose the job, right? So both of you are in a circumstance where it does not behoove you to lose work authorization. And just to put a button on it before I become long-winded, it's really important to look at the very first part of this interim final rule because it does what this administration does the best. Hates on Joe Biden. The whole preamble of this talks about the idea that, hey, these last changes, right, where we implemented 180 days of work authorization and 540 days of work authorization, those were done by open borders Biden. Open borders Biden let everybody into the country. He gave everyone an EAD benefits. Somehow, if you're, a Caucasian person, you're somehow paying for poor immigrants' household or something. Look, that's their basis, right? Joe Biden is responsible for opening borders and letting people in, and we just got to vet all these people. We got to make sure that these people are vetted because we don't know. They could all be terrorists, right? The turn, because you have to explain why are we making a rule that is drastically different than the previous rule, right? So the turn is we got to close everything back up, and these people that are in here could be terrorists. We don't know, so we got to be careful, and we just don't know. Okay. If you really want to extrapolate it down and say, okay, well, who are the people that you guys are worried about? Like, who are the people that didn't get vetted? Maybe your TPS people, maybe your asylum people, right? There's a lot of buckets for the EAD, okay? And to make this argument that everyone who's an EAD person, a green card holder, or a H4 holder, H4 EAD holder, everyone goes in the same bucket is ludicrous, right? The level of review that's going into someone who's applying for an adjustment of status is very likely not the same level of review that's going over somebody that's being screened to enter the country with an asylum claim, right? A person applying for an adjustment of status has typically resided in the United States for, a while, unless they're marrying a U.S. citizen. There is data points on them. There's information on them. They can be reviewed and screened. The same thing applies with someone with the H4. To get into the country at some point, you had to have a visa. After you got the visa, you had to be inspected and come in through CBP. Once you got here, you've likely applied for an extension in the past, under which time you've been reviewed. At any point, if you have a run-in with law enforcement, you are immediately put into a database where they analyze it. The State Department now, they're just canceling visas. They're not even looking at what's been done. They're like, we're going to cancel visas, okay? So they have that information. So what's really changed? What's really different in this circumstance from the one before? It's just the notion that we realize that there's a problem in our system and we're going to address the problem. Now they're saying we realize there's a problem in our system. We don't want to address the problem because national security. And that's it. And that's what they're going to hold on to in court. They're going to say, hey, national security is the most important thing we got to look at. We got to protect American citizens. And we'll run that against everything else. But yeah, that's really it. I mean, on the privilege aspect of it, it's a pretty nonsensical statement, but I'm not surprised because the entirety of the IFR is draped in stupidity.
Thank you, Justin, for taking that up, really. And it's all true, whatever you said, a lot to think about, a lot to take in. And friends, I hope that you are with us. And don't forget to leave a like. I hope you're enjoying this whole session. We are Immigration Talk Show. Check us out on LinkedIn, Facebook, YouTube. Don't forget to subscribe. Our channel is at Immigration Talk Show and hit that bell icon so that whenever we have discussions like these, you are notified, you can participate and ask your questions. Also, if anyone out there wants to join on call, you can be live with us. And the number is 425-436-6335. The access code is 988888. So join us on call. We are waiting if you want to join us. And we do have Samantha also who has a question. How should employees revise their internal compliance protocols and onboarding timelines to accommodate potential disruptions in EAD validity for H4 and L2 dependents?
I mean, that's an interesting question, but I think that question is based upon the idea that this will be long-standing. And I don't know if that's necessarily true. In terms of now in the short term, look, that policy went in on October 30th, right? It said on or after, not after. So 10/30, if you filed on that date or you file after that date, you lose the benefit of the auto extension if you qualify for it. So what is the plan here for those individuals? I mean, obviously, the safest idea for an employer would be to terminate the individual. I don't know if that's necessary. My argument would likely be if you could put them on leave, leave without pay, so you don't have to terminate their position, rather than having to terminate and then go through the rehiring process. Obviously, you're going to have to I-9 them when the EAD comes in, but I think it's easier to just have them on leave, leave without pay. The issue with the EAD is work authorization, right? Are you performing work for the company? So if you're not working for the company and the company is willing to hold you, then I think holding pattern the employees. Just make sure they're not doing work for the company and then wait for their EADs. Now, the problem's going to become, because we saw this happen under the last administration, a company can only hold for so long. How long can you really wait for someone to do their job? I mean, if they blow all their PTO and then they're on leave, pay without leave, or they blow all their sick pay, eventually the company's going to operate at a deficit, right? Because they have a hole and they don't have an employee working, and even if they're not paying that employee, it's still a loss to the business. So I would say try to hold them and utilize expedite requests and then join litigation if you can, because that's really going to be our only way moving forward, at least in the short term.
That's right, Justin. And talking about, what we just spoke, the leave without pay or unpaid leave. What does it say about the system when a worker with an expiring EAD is told, by HR to prepare for unpaid leave?
The government is currently fighting in court to make sure that they don't have to pay SNAP benefits while the country is closed down. Like, I don't know if I can put any more plainly to you that there is a level of genuine cruelty to this administration, and it is the point. They don't care. They don't care. I think that the fact that there is a prolonged targeting of legal immigration already, lays bare the fact that the statements that were made prior to the administration coming into power are just not true. Um, there is a desire, Miller, to eliminate immigration in as much capacity as they're able to do so. If you asked them tomorrow if you could flip a switch and everybody that had immigrated to the United States would be then told that they are no longer here legally, would you do it? They would likely say yes. Or to be more candid, they would create a system where if you were rich and had a lot of money and could pay them to stay in the U.S., you could do that. But outside of that, they would turn it off for anybody else. And so, yeah, I get that it's not fair to people that are trying to do things the right way, but they're not going to care. I think that if employers are willing to help soldier this forward, they're willing to help their employees in any way possible, be that through unpaid leave or, just holding their positions or whatever they can do for them, then it'll go a long way. But it's very reminiscent of where we were in the first administration, where this was a tool they rolled out. They didn't really want to listen to anybody saying, hey, this isn't going to be a good idea or this is going to be harmful to people, because they were like, yeah, of course it's going to be harmful. That's why we're doing it.
Yes, that's right. And, Justin, talking about it, I just want to end it with Robert's question because, he's saying, given the backlog and processing delays at USCIS, How might the proposed EAD renewal changes interact with litigation trends or class action suits aimed at protecting work authorization continuity? Do you think it'll continue?
So what's really interesting is part of their argument, which is really it's interesting is a nice way to say stupid. Part of their argument is that the backlog is going to go down because there's going to be less frivolous and fraudulent EAD applications, right? Because open border Joe gave everyone an EAD card and probably a check for $100,000 and some patents and whatever. That he likes immigrants more than he likes you, right? That's the whole argument against Joe Biden. So because of that, because there's going to be less people applying because they're getting rid of TPS categories, making asylum cases harder, doing those things, there'll be less people that are having to adjudicate those applications, and they're going to focus their time on your application instead. The federal government and the word efficiency are, oil and water, right? The idea that the federal government is going to somehow magically become more efficient because of this is asinine. I very much doubt that an employee who is, slogging through a colossal backlog of EAD applications is going to go, golly gee, I'm just going to work so much harder now because I know I don't have to adjudicate these bogus TPS EADs. So, go ahead and read it. I'm not lying to you guys. It's in the IFR. You can go read that justification. So yeah, the backlog and processing delays are going to continue and they're going to get worse. Of course they're going to get worse. That's the point. They're going to shift resources to put people in places that they deem are the most important to them. I guarantee you those places are not going to be EAD adjudications. And as a result, you're going to see a continuing problem with backlog. Okay. So how does this work with litigation? This is exactly what we're basically arguing when we file suit against them in December. Your IFR is bogus. There's no reason for you to not go through actual APA litigation, which is notice and commenting period, several months, the way it's supposed to be implemented, because there's no immediate danger or harm like you posit there is. But furthermore, when you look at the justification for it and then run it against the negative impact that it's going to cause, it just doesn't make sense. One of the things that I was talking about with another attorney, which was really interesting to me, and I thought that they made a great point. If the 540-day rule is so egregious, why wouldn't they just drop it back down to 180? Right? There's a middle ground that exists here where you could say, okay, 540 is ridiculous. It's too long. We're going to drop it down to 180 and say that we're going to be able to get to the person's case, if they file 6 months out, within a year. So you do have that sitting there, but we can't do it, right? Because national security, we got to drop it all the way to nothing. And so, yeah, I mean, it's ripe for litigation. I'll leave it at that. It is ripe for litigation. Whether or not it be class action, I can't say. I know that there have come out of the Supreme Court over the last year that have kind of lessened the impact or the power of the nationwide injunction, and I think they've also probably bled over into making it more difficult for class action. So I don't think that that's the way we would go. If another firm is looking to do that, then more power to them. The more bites we're taking into the administration, the better we're all going to be. There's a reason why we celebrate when other people sue the government, even if it was something we wanted to do. There's a lawsuit on the $100,000 fee right now that's been filed by the Chamber of Commerce. Awesome, great argument. Jealous of it a little bit, but excited about the prospect of their success. Even though it's not something we did. So our industry, I feel, not to pat us all on the back because we're not all great. There are shitty immigration attorneys out there. Don't get me wrong. But by and large, the people I've been working with, what I have noticed and been very appreciative of is the vast level of collaboration. The idea that even if we're not all claiming the glory, we're all trying to win because we want you guys to win, right? We didn't get into this job just to make money, or at least most of us didn't. We got into this job because we genuinely believe in immigration and its importance to the United States and how it strengthens our country. And there are tons of us, and we all were smart enough to go to law school, And we're now trying to sue the government to make sure that they can't do this kind of crap. And I think that we have been pretty successful this year, to be honest. I mean, if lawyers didn't step up and block that SEVA stuff, we would have been in a world of hurt. Not to brag too much about our firm at the end of the call, but I know for a fact that, there was some bullshit technicality that they were trying to play with signatures on H-1Bs. They were trying to revoke a bunch of people's cases or deny cases because of signatures that were digital. We pushed back on them hard enough that they gave up. And so, because they knew we were going to sue them. And so once we cannot take our foot off the gas, right? We have to keep applying that same level of pressure anytime one of these nonsensical rules comes out. And that's what we're going to continue to do. So I will leave you with that and a little bit of positivity in that if you are a potential plaintiff, please shoot us an email. Let us know. We can talk to you more about the case. We also have a GoFundMe that we're using for the litigation that if you would like to contribute to, you can. We are using that GoFundMe purely to pay for experts. That's it. We're using it because we're going to need to get experts and look at economic impact studies and things like basically doing the work the government should have done in the IFR to take to court. So if you're able to contribute, that's awesome. If not, all good. But I do have to leave now. So thank you guys very much for your time and the opportunity to speak. It's always nice to get to talk to somebody other than my dog.
Thank you so much, Justin. It's really, I mean, we really appreciate your time and all of the answers, the questions you took in for us today and leaving us with this positive note today. And let's just not give up on hope and do what's necessary. And thank you once again, Justin. I hope to see you soon.
Sounds good. Thank you for having me. You guys have a good day.
Thank you. You
Bye.
too. So, friends, that's it. And thank you so much for joining us here on Immigration Talk Show. Don't forget to check us out. We are on YouTube, LinkedIn, Facebook, X, and on Instagram. And subscribe to our channel on YouTube. Our handle is at Immigration Talk Show. Also, hit that bell icon so that whenever we have discussions like these, you're notified. And I hope that was a good session today for you, and especially ending on with some hope today being 11/11. And let's keep on manifesting and hoping for the best. And don't forget to also check out Boston Immigration Litigation, and in fact, reach us, on our email, our phone number, and check out Attorney Justin Rivera as well. You can check him out on this link you can see on the screen. And also reach out to me on my number 408-335-6444 in case you want to know what is the email address also for reaching out to Wasden Immigration Litigation. And my email is nipa@staffingly.com. So this is it for today. Thank you so much for joining us, and stay tuned on Immigration Talk Show because there's so much happening and we keep bringing them up to you. Also, there's another webinar lined up. So yes, keep a reminder for that as well. Thank you for joining us. Bye for now.